reported that the water valves had in fact been forcibly turned back on and were vandalized and filled with rocks and sand, preventing them from actually being turned back off again. So, water lines. Mr. Hayes attempted to inspect the meter on Mr. Furlong's property, but Mr. Furlong denied him entry to the property. On September 23rd, 2015, Mr. Hayes, along with the work crew, went to the Route 302 location in Bartlett in front of Mr. Furlong's property. Mr. Hayes was there to excavate the area surrounding the water precinct shutoff valves and to remove the rocks and sand that had been previously placed there. The Bartlett Village Water Precinct had still not received any payment or assigned payment agreement from Mr. Furlong, and the water shutoff valve to Mr. Furlong's property had again been determined to be forcibly turned back on and vandalized without the permission or the authorization of the Bartlett Village Water Precinct. Due to no, it was confirmed again. They looked further and confirmed again it was shut off forcibly. Because of ongoing issues between the Bartlett Village Water Precinct and disputes, and there's been ongoing litigation between them over the years, and with Mr. Furlong, Mr. Hayes hired a detail officer, Officer Michael Champlin, not Champlin, not related to me, different last name, from the Bartlett Police Department, who arrived on the scene at approximately 9 o'clock a.m. And Officer Michael Champlin witnessed Mr. Furlong drive his van over the shutoff valve that's adjacent to the street, and it's the property of the Bartlett Village Water Precinct. And because Mr. Furlong had driven his van directly over the site there, they were not able to excavate to make the repairs that were needed. And so at approximately 9:30 a.m., about a half an hour later, I arrived on the scene because Officer Chapman had called me, and I did observe Mr. Furlong's van, recognized it to be his van, the 1999 Dodge, parked and locked directly over the shutoff valve. I then approached Mr. Furlong, who was sitting outside of his front porch of his house. I asked him to move the van and advised him if he didn't, it would be towed. He refused, and I then requested for a record to come and tow the van. At that time, Mr. Furlong made a statement that he insisted that the Bartlett Village Water Precinct had no right to turn his water off. Approximately 15 minutes later, Mr. Furlong, while we were waiting for the record to arrive, he ran up to his van, unlocked it, jumped in it, moved it about, less than 4 feet away, locked it again, and ran back to his house. I asked Mr. Hayes if the movement of his van would allow them to do the excavation that they needed to make the repairs on the water line, and he advised me they still wouldn't be able to. It would be impossible for them to do it safely because the van was still parked too closely to the valve and the excavation site. And I measured the van to be now about 4 feet away from the actual valve that they needed to dig around. So Mr. Furlong continued to refuse to remove his van from the site. At approximately 10:45 a.m., the van was towed from the scene. Mr. Hayes and his crews were able to begin excavating the site. During this excavation, it was confirmed again that the shutoff valve had indeed been vandalized in order to jam it open and for the water to flow. At that time, Officer Chapman, who had remained on the scene for the remainder of the day while the work was done, recovered a black latex glove in the hole right next to the shutoff valve that had been vandalized, and inside the glove was white paint. We had all observed that Mr. Furlong had been painting one of the buildings on his property with white paint. That glove was taken into evidence. At approximately 11:15, Mr. Furlong exited his driveway of his residence in another one of his vehicles. I was still at the scene, and standing along Route 302, Mr. Furlong, who had previously been yelling at me and filming me with a video camera, rolled down his passenger side window, and he was yelling at me and waving a stack of white papers in his right hand. He then proceeded to throw the stack of papers, which were stapled together, onto the roadway of Route 302 and drive away. I have, and I'm entering these into evidence, the repairs were able to be made at that point. I have since gotten receipts for all of the repairs that were needed. The total amount was $2,545. It was $1,095. This is the Exhibit A from Dawson's Excavation and Utility Services, and it details the work that had to be done in replacing and repairing the shut-off valves that were vandalized. So this is one exhibit. And he's got a copy. He's got full discovery. And the exhibit number 2 is from Iron Mountain Water Services from Mr. Hayes. Work that they had to do, and that totaled $1,460. And this is the other evidence it costs. What I haven't submitted, and I'll add to this bill, is the $270 that it cost the water precinct to pay for Officer Chapman to be there for the detail for the day. So the total for everything was actually $2,815 to repair the damage. Once I received these receipts on October 6th, I prepared this arrest warrant with my affidavit and complaints against Mr. Furlong. Your Honor, Judge Patton reviewed them and signed them here. And on October 18th, I had telephoned Mr. Furlong and advised him that I had this arrest warrant in effect for him, and I knew he was going to be in court in Ossipee on October 20th for a hearing on civil matters. And just based on his previous arrest history, I wanted to let him know that we would be effecting that arrest warrant there, making it more convenient for him. During that phone call, when I advised Mr. Furlong what the arrest warrant was for, criminal mischief, I'm sure I have all the charges here. It was for this Class B misdemeanor criminal mischief, disorderly conduct, and breach of bail conditions because he was out on bail on previous charges already. Mr. Furlong stated to me that the Bartlett Water Precinct had no right to turn his water off, and he stated that he had the right to have done what he had done to get his water turned back on. He was then, in fact, arrested on October 20th at the Ossipee Courthouse by the Sheriff's Department. And the state rest of the case involved in criminal mischief.
Thank you, Your Honor. Chief, you used the plural when talking about these shut-offs. How many were there?
Excuse me. I believe there are 3, but I want to make sure I'm certain. I believe there are 3 because Mr. Furlong has 3 different properties there. He's got his house, he's got cabins, and he's got his business. But just for clarification, Mr. Hayes had stated that they were all vandalized.
Okay.
Whatever shut-off valves there were vandalized.
Okay.
And those were all the properties were.
So there would be no water to his house or to his business or to the rental cabins?
That they were shut off?
Yeah, when they were shut off?
Whatever they shut off was to shut off to whatever those went to, yes.
So is your understanding that all 3 had been shut off initially
it's my understanding
on September 11th?
Yeah, it's my understanding that at least 2 of them had been shut off,
okay.
The cabins and his house.
Okay. Now, when Mr. Hayes came out on the 22nd to inspect, and let me ask you, are these shut-off valves, are they down below the ground or are they on the surface of the ground?
They're both.
Okay. How is that? Explain that to us, please.
One of them, I believe, is a little bit above the ground, but the two, and especially the one where the latex glove was found along 302, is actually below the ground, about approximately maybe a foot.
Okay.
So the person, we're alleging Mr. Furlong, would have had to dig that up.
Okay.
Pretty simple to do that.
So on September the 22nd, did Mr. Hayes dig those up? Those shut-offs that are below ground level?
I believe so, yes.
So 2 below ground, 1 above.
Yes, I believe so. If I could take a look at my file there and look at Mr. Hayes' statement, I just want to be accurate about this. I apologize, it's a pretty thick file. Let me show you here. Together again through here. Your Honor, there were 2 shut-off valves. Both of them had to be removed from dirt and then turned off. That was originally. So there were 2.
Not 3.
Not 3, there were 2.
Shut-off valves.
2 shut-off valves. Yes, Your Honor.
And do you know which valve controlled access to which part of Mr. Furlong's property?
I do not.
Okay. So your understanding that the 2 shut-off valves, when turned off, would have eliminated water to the house and the business and the rental properties?
At least 2 of the properties.
Okay. And were those rental properties occupied at the time?
I believe one of them was.
So, I guess my question was, when Mr. Hayes first inspected the valves, and is it not actually correct that he first inspected on the 21st of September and reported back that the valves had been reopened? I'm going to refer you to the statement of David Ainsworth that you should have there. I got it from you.
On September 21st, the shut-offs were still off. And then they received a call they were back on.
Okay.
So Mr. Hayes turned them off and took pictures to show the position of the shut-off tool that indicates off and on.
And that was on the 21st?
That was on the 21st.
Okay, so they had been turned on once and he turned them back off on the 21st?
Correct.
Okay. So then on the 22nd was when Mr. Hayes, your understanding is, found that the valves had been propped open with rocks and dirt?
That's correct.
Okay. So here's my question. How does he know that without excavating?
They're not that far in the ground.
So he did have to excavate, just not very far?
Not very far.
Just take a shovel and...
Yes.
Okay. There are markers, are there not, to indicate where those valves are, the one that's underground?
That's correct.
So anybody should be able to figure it out, right?
I can't answer that, but he knew where, he's done work there, so he knows where the valves are.
Okay. Where the van was parked on the 23rd, where the van was parked, whose property is that?
That's right away, public property.
I thought you said it belonged to the village water.
I'm sorry, I misspoke. The valve that Mr. Furlong parked his van over is the property of the Bartlett Water Precinct. However, it's within 30 feet of the middle of the roadway there, which is a public way, so it's a right of way.
Okay. Nobody's actually seen Mr. Furlong touch these shut-off valves at the time in question, correct?
That is correct.
No nobody knows whether he was the one who tampered with the valves or whether someone else did it, correct?
No, that's not correct. We don't have an eyewitness, but circumstantially, based on Mr. Furlong's actions and his words to me...
I get circumstantial evidence. My question was nobody knows. Right. I understand you have circumstantial evidence that it was him or we wouldn't be here.
Right.
But nobody knows. Right?
We do not have an eyewitness, actually, who could testify that they saw him do it.
Okay. And you don't have, other than this glove, any physical evidence that connects him to actions taken on these valves, right?
Other than his admission that he did it.
We'll get to that in a minute. We'll get to that. The only physical evidence we have is his glove.
That's correct.
Glove doesn't have his name on it, right?
That's correct.
You're drawing a conclusion because there's white paint on the glove and he's been painting part of one of his properties white. Must be his, right?
Well, I'm not drawing a conclusion. I'm building
You're drawing an
probable
inference.
cause.
Okay, you're drawing an inference.
It's a good possibility.
Good possibility, okay. Has this glove been sent to any state lab or any lab?
Yes.
Okay. What analysis has been requested?
For fingerprints. We don't have that back.
Okay. Any heads up from the state lab as to how long it's likely to be?
I do not.
All right. Any testing requested of the paint for comparison purposes to any other paint?
No.
Do you know for a fact that Mr. Furlong was the only one doing any painting on that property?
I do not know.
Okay. You don't know whether he had somebody else to do it
I do not know that.
or to help him with it?
I don't know that.
Okay. Did you search his property to see if there were other latex gloves that might match that one?
No. Well, we need a search warrant for that. I didn't fill it out at that time.
Now, you testified that after you got your arrest warrant and you talked to Mr. Furlong to arrange to serve that warrant on him, that he stated Bartlett Water Precinct had no right to turn his water off, right?
That's correct.
And you were, of course, aware that that had been his position for quite some time. And that he had the right to have done what he had done. Can you tell us exactly what words he used in making that statement?
He stated he had the right to have done what he had done.
Yeah, no, I'm not asking you to read what's in your affidavit or in your report. We've already seen that.
Those are the exact words. That's not what he meant.
I have the right to have done what I had done to get my water turned back on. Those were his exact words?
Yes.
Are those recorded in any way, other than being in
not
your
by
report
me,
here?
no.
Did you write them down?
Yes, I did.
Did you ask him to confirm that that's what he had said?
No, because I heard what he said.
Was there anyone else present?
No, it was a phone conversation. I was at the police department.
Okay. You were using the phone that's recorded.
I was using the police phone, but it's not recorded.
Not recorded. Did you state to anyone else after that conversation that Furlong just told me he did it?
Yes.
To whom?
I think one of the officers who was working, probably Officer Sheehy. I've had many conversations and emails, as you know, with Mr. Furlong. So I would have probably told
In other words,
Officer Sheehy.
you don't recall what you did?
Oh, I know that I told at least one of the other officers there.
Okay, no documentation of that?
I think my recollection is, I think I said something like, well, now he's admitted this to me again.
Okay, no documentation of it though?
No,
Okay.
other than what's in my report.
To your knowledge, did you or any other officer talk to any of the tenants of any of these rental cabins at that time?
At that time, no.
Have you or other officer, to your knowledge, had any conversation with any of the tenants at any time concerning this question of water being turned off, turned back on, turned back off?
Yes.
Okay, with whom?
Well, about 2 weeks ago, a gentleman came to the police department while I was there to say that he was moving out of one of the cabins. I don't remember his name. And he just wanted to give us a heads up. And what he told me was that he was on a month-to-month lease. He had paid up. That he had many conversations with Mr. Furlong about why the water was turned off, and he had been paying for water to Mr. Furlong.
Right.
And
before you go too much further, let me ask, is this specifically with relation to the events in September?
well, I'm answering your question.
Yeah, I understand. Is this with relation to the events of September? Because that's what we're talking about. If it's about something else, then...
Right, I believe it's a civil issue, so for that purposes of this hearing, no.
Okay. Do you know whether that individual was living there in September when this was going on, when these events were going on?
I believe he was.
Do you know?
I believe he was, just based on what he told me.
Okay. Were there any other tenants in any of those cabins during that period of time?
Not that I know of.
Okay. Did you or any other officer do any inquiry?
Mr. Furlong's made it abundantly clear that he does not want any law enforcement personnel on or around his property. So I have no way of going in there and finding out that information.
Is there any sort of documentation that the town requires when someone's renting out a rental property? I mean, is that data that the town collects?
I don't believe so, no.
I'll show you two pictures. I know you've not seen these before. I haven't seen them before today either. You able to tell us what those pictures are?
I can't tell from that angle, no.
Are you able to tell us whether that looks like the area outside of Mr. Furlong?
I will say this looks like 32, and that looks like the water, the valve that Mr. Furlong put his van over, but I couldn't say for sure.
And that's above ground, right?
That part.
You can see it. You can see the valve in this photo with the earth not even having been disturbed, correct?
Well, that's correct, but there's a mechanism underneath there. This is how it's explained to me. It's an education for me, too, about how these wells work. You actually have to dig a little bit down there. So that's what it looks like to me, but I couldn't say.
That photo, LTNE, or...
Yeah, again, that looks like it. I mean, I see a Bartlett cruiser there. I can make a few assumptions, but the photos that I took that I provided to you were when Mr. Furlong had his van parked there.
Right.
So this to me appears like it's the aftermath after the repair was done.
But again, these valves are visible above ground, right?
The top of them are, but there's a mechanism that's below.
I understand. So the fact that the top of them are visible above ground indicates anybody can see it.
Sure. You can see that part of it.
I think that's all I have, Judge Lincoln.
No, I think that's it.
Anything further, Mr. Merkin, on behalf of...
No witnesses, Your Honor.
Arguments?
Well, were it not for the claim that Mr. Furlong acknowledged having done something, then I would say the state absolutely has no probable cause whatsoever that he's done it. All they have is inferences they want to draw. We do not concede that that statement was made. I'm concerned that it was not recorded in any way, that there was no attempt to question Mr. Furlong under controlled circumstances that day or the day he was arrested to recreate that statement, that we have nothing but the Chief's word for it. On the writing or on the words that she wrote in her report and claims those are exactly the words. We don't accept that. However, for probable cause purposes, I have to leave that to the court. I don't think the state has a case here that they can proceed into a conviction upstairs because they have no witness, they have no smoking gun, they have no physical evidence that ties Mr. Furlong to any of these actions. All they have is he expressed he was unhappy about his water being cut off, which most anybody would be, but that falls short of being able to prove that he tampered with the shut-off valves. In the absence of that, I would say the state doesn't have enough to go forward because they can't prove a case.
Well, of course, Your Honor, I do disagree on all counts. Again, this is a probable cause hearing. It's not a reasonable doubt hearing. It's just a matter of someone who's not simply unhappy about their water being turned off. Mr. Furlong has been in lengthy litigation over many years regarding the Bartlett Village Water.
That's not in evidence, Your Honor.
There are also other pending charges, as this court is aware of, that pertain to the Bartlett Village Water Precinct.
I would also say that's not evidence for purposes of today's hearing.
I can't ignore what
I understand the court knows that, but that has nothing to do with what's been here.
Mr. Furlong not only has a motive, the opportunity, and he did give me an admission, and I am quite certain of what he told me. I wrote notes while I was speaking with Mr. Furlong. I've had a few years now of interactions with Mr. Furlong, and he's made it very clear that he will not be interviewed as far as tape recording is concerned.
It's all stuff that's not in evidence at this hearing. What Mr. Furlong may have made clear on other occasions in other cases.
Your Honor,
argument at this point, I'm just continuing.
yeah, Your Honor, I'm responding to what the defense counsel has said. As far as tape recording, as we know that it's illegal for me to tape record Mr. Furlong without his permission. He wouldn't allow me anyway. He's made it abundantly clear that he doesn't want police on his property. What he admitted to me is exactly what he said. This again wasn't just a simple being not happy with the water being turned off. This is a bigger issue for Mr. Furlong. His actions at the scene, moving the van over to block it, I think it's further evidence. And again, it's definitely enough probable cause, state believes. Obviously, we're not at a reasonable doubt point, but for probable cause purposes, we believe the state has proved its case. Should take it to Superior Court.
Well, absent that statement, I would tend to agree with Mr. Murphy. So what I'm going to do is focus on that evidence that's been presented and the words purposely damaged shut-off valve and determine whether or not there is sufficient evidence to support a probable cause finding in those respects. I'll take the time to do that by taking it under advisement and issuing a written decision. Thank you very much.
Thank you, Your Honor.
Structure these entities. Anybody got any good ideas about how to do that?
Your Honor, I think the only one that was on for today for structuring was the County Sheriff's case, 15 CR 297. The others are on for March 8th, which is a date we're going to have to change, but we'll talk about that later.
Okay. We have 3 complaints.
Right.
One Class A, 2 Class A's and 1 Class B. So you're representing them on the Class A's, I assume?
Yes.
And we have the Class B. Are you going to...
What we usually do, if they're all part of the same case, we just do them all.
So, how about pretrial discovery? Is that reasonable?
There is an issue pending. Before we got involved in the case, Mr. Furlong had made a discovery motion pro se, and the issue that's before the court has to do with telephone records of the complainants in that case.
So discovery of telephone records of complainants.
Right.
And there's a pending motion.
There's a motion, I think that's before the court.
The motion, that's the state file and objection.
State would object.
Let's get it for hearing. No, not specifically. Do we need a hearing on it, or can I decide it on the things?
I think we can decide on plea.
Yes, Your Honor.
Okay, so just hang on a second. Telephone records of complainants. Motion and objection. To be decided. pleadings only, okay? Any other pretrial discovery concerns?
I think we're going to be asking to take the depositions of the complainants, and as they live in Massachusetts, that's going to be a production.
True. How many are there?
There are two.
Two. Depositions of two witnesses, residents of Massachusetts.
Correct.
Knowing the production value of that request, what do you suggest in terms of scheduling things so that depositions are all complete by?
End of May.
30 days, that's a good thing. 5/31/2016. Would that then resolve all discovery, pretrial discovery?
I would think so.
State NTSA on that, so, and then, how many hours, days?
Guessing between 2 and 3 hours. In May.
How many witnesses?
I'm only providing 2 officers and 2 victims.
Okay.
Don't know at this point. I don't think we have a lot of witnesses, but
I was going to say 2.
2 hours seems like probably not enough.
All day?
A whole afternoon or morning, whichever.
Let's do a half a day after June 1.
Cases booked through the end of June. I will be looking in July. I already have a half day on July 12th for another public defender case. So I will be looking...
I'll do it that day then.
No.
Usually it's from the...
No. If we could do the morning of July 19th.
So the 19th, 16th, starting at 9.
Can we do the 26th? We've already got something in Belknap the 19th.
That's not good.
Okay.
We
Well,
can do the afternoon, it just leaves me with 2 back-to-back Tuesdays.
yeah, no, I don't want to do that to you. Tell you what, let's put it on for the 19th, because what I have in Belknap, we can always move. It's either a dispo, it's a final pretrial, we can always move it.
So 7/19, 16, 9 a.m. for 1 half a day. I'll do a brief structure order addressing when depositions will be completed by. I'll leave it up to you and the lieutenant to figure out the logistics of that. And I'll act on the motion for telephone records on the pleadings as quick as I can.
Okay.
And that's the only thing to be pre-tried today.
Yes.
And just for clarification, are we still on for March 8th?
We need to talk about that, because I'm going to be out of town that week, and actually Mr. Furlong is as well.
I guess not.
What was scheduled for March 8th?
That is pretrial on the various remaining misdemeanor cases that we have in Bartlett.
When do you want to? When do you want to do those?
When do you come back? 14th. Okay, you're back the 14th, I'm back the 14th, but I've got trials in Belknap Superior starting the 14th, so
Sometime in April, maybe.
is 29th available of March?
Hold on. Still trying to plug in the other one.
Sorry.
Okay. March 20th. You're not here that day.
Okay.
Well, that's good for me.
Schedule it right then.
We could do,
As long as all of these trials get scheduled for December 13, 2017, after almost
we could do the retrial, the after, 2:30 on April 5th.
4 or 5, 2:30.
I got a doctor's appointment.
Okay, hold on. we don't want to go any earlier than March 29th, is that what I understand?
Well, see, the 14th and 21st are trial weeks in Belknap Superior. Right now, I've got 4 cases set in there.
Let's just find something else, that'd be good.
How about April 19th?
Instead of March 8th?
Yeah.
That is you said April 19th?
Yeah.
For some reason I have no questions that day, you must not be here that day either. I don't know either. Or a family division might have taken that day only.
Or can we, is there a non-Tuesday we can do it?
Do it today. Reach out, right?
I can go grab the files if you would like to. 26th is a civil day, so I'd be looking at May 3rd.
5-3.
2:30?
Remember, remind yourself and me to make sure we have a list of what we need to address on the list. 5-3-16 at 2:30, so pre-trial, all remaining matters otherwise scheduled for March 8th.
And in the meantime, we have not filed it today, so we'll break it up today, but we are going to file a motion to amend bail on those. Mr. Furlong's posted a fairly substantial gap bail, and I don't think it's justified. The motion